Faded crown. They called it a design review, but it was really just Vanessa Langford standing at the head of the boardroom table in her charcoal theory blazer and $300 blowout, clicking through my seismic compliance model like she'd dreamed it up during a meditation retreat in Queenstown. "This lateral bracing solution is something our firm should be deeply proud of," she said, voice smooth as polished concrete, one hand gesturing toward the projection screen where my calculations glowed in blue and white. "Our firm. 14 months of work, and she said our firm like the building would have stood without me. That bracing solution came to me at 1:40 in the morning, hunched over my kitchen table in my flat in Arrow Valley, sketching load paths on the back of a pack and save receipt while my cat knocked a half-empty mug of Milo onto the floor. I'd spent 3 straight weekends running finite element analysis because the soil reports from the Hutt Valley site came back worse than anyone expected, liquefiable layers at 4 meters, and the original foundation spec would have folded like a deck chair in a moderate shake. But please, Vanessa, do tell the council liaison about your vision." Afterward, I sat in my car on Lambton Quay with the heater running, watching rain streak down the windshield, gripping the steering wheel so hard my knuckles went white. That's when I knew I wasn't just tired. I was furniture. For years at Langford Fenwick Associates, I'd built the structural backbone of every major project they'd landed since the Christchurch rebuild contracts dried up and the Wellington market got competitive. The Pet One waterfront apartments. The Kapiti Coast Retirement Village. The Pereira Civic Center that won a bloody NZIA award, my name nowhere on the plaque. And now I was the backroom calculator, the one they called at 9 p.m. when the numbers didn't add up but couldn't be bothered to credit when they did. Over flat whites at Customs Brew Bar that evening, I vented to my oldest friend, Ruiha, who worked in resource consent at the council. She listened, stirred her coffee, and finally said, "You know what you are? You're the foundation." Literally. They build everything on top of you and then act surprised when someone asks who poured the concrete. I laughed, the bitter kind that tastes like cold coffee and resignation, because she was dead right. Now, quick pause. If you're still here and haven't subscribed to Faded Crown, you're part of that silent majority coasting through these stories without tapping the button. It takes half a second. A like goes a long way too. We notice. We appreciate it. Alright, back into the wreckage. Vanessa wasn't just taking credit. She was building a career out of my invisible labor. Every client meeting became a one-woman show. I'd present a structural update and she'd cut in with what Kira is trying to say is, like I was some graduate who'd wandered into the wrong room. She'd rephrase my analysis in softer language, strip out the technical precision, and serve it back like she'd baked it herself. The partners would nod. I'd sit there holding my pen so tight the clip bent. But the real gut punch landed on a Tuesday morning in March, right after a long weekend I'd spent recalculating wind loads for the new Thorndon mixed-use tower. Vanessa walked past my desk, heels clicking on the polished concrete floor, and stopped with that smile. The one that looked warm from a distance but up close was all teeth and no eyes. So we'd decided to bring Toby onto the Thorndon project as lead structural coordinator. Fresh perspective, you know? Mentorship opportunity. Toby. Marcus Fenwick's 24-year-old nephew. The same Toby who graduated from Canterbury with a civil engineering degree he treated like a souvenir, who once asked me if moment of inertia was a yoga thing, who wore designer sneakers to site visits and called my spreadsheets vintage. That Toby was now lead structural coordinator on a $42 million mixed-use development in an earthquake-prone capital city. I looked at Vanessa. She was already scrolling her phone. "If you have concerns," she said without looking up, "there's a process for that. You could always raise it with Marcus. But I'd think carefully about how that looks. Coming from you. Coming from me. Not from a senior structural engineer with 4 years of flawless delivery. From me. Like my professional standing was something embarrassing I should keep quiet about, a stain on the carpet nobody mentions at dinner parties." Something shifted in that moment. Not a snap, more like a slow geological fault finally slipping. I smiled. I nodded. I even said, "Sounds great, Toby's keen to learn." Then I drove home, opened my laptop, and started digging. See, before Langford Fenwick Associates existed as a proper firm, back when it was just Marcus and a part-time office manager working out of a converted garage in Newtown, I was the first engineer he brought on. Not as an employee. As a contractor. Independent. My own ABN equivalent, my own invoice template, my own terms. I'd been fresh out of uni, hungry, willing to work weekends for a flat rate that barely covered my rent and my student loan payments. Marcus needed someone who could do structural analysis fast and cheap while he chased clients, and Vanessa handled the architecture side. Those first 18 months, I designed the structural systems for 3 residential projects and the foundation spec for a small commercial build and lower hut. All under a contractor agreement that Marcus had drafted himself, 2 pages, barely legible, signed on his kitchen table over a 6-pack of spades. I found it that night. Buried in a folder on my external hard drive labeled "Old Stuff, Don't Delete." The agreement was clear, almost comically so. Clause 4, all original engineering designs, calculations, and structural specifications produced by the contractor remain the intellectual property of the contractor until formally assigned in writing. Formal assignment hadn't happened. Not when I transitioned to full-time. Not when they incorporated. Not during the HR onboarding that consisted of Vanessa handing me a lanyard and saying, "Welcome to the team," as if I hadn't been holding the team up for a year and a half. They took my work. They built their reputation on it. But they never took the rights. I sat on that knowledge for 3 days. Didn't sleep well, didn't eat much, just kept rereading Clause 4 and staring at the ceiling. Part of me wanted to let it go. Walk away, find another firm, start fresh. Wellington's small, but there's always work in Auckland if you don't mind the traffic and the rent that makes your eyes water. But then Toby started. The first thing he did was change my naming convention for the structural files. Just renamed everything to match some system he'd learned in a third-year tutorial. Broke half the cross-references in the calculation sheets. Then he told the drafting team to update the foundation details using a template he'd downloaded from some American website, Imperial Units, and all, for a New Zealand building subject to NZS 1170 and NZS 3604. I caught it during a routine check. If that had gone to council, we'd have been laughed out of the consent process. I flagged it. Quietly. Professionally. Sent Toby an email, CC'd Vanessa, attached the relevant standards, highlighted the errors. Vanessa's response came 40 minutes later, not to me, but forwarded to the whole project team. Team, let's keep feedback constructive and forward-looking. Kira, perhaps you could support Toby by preparing a brief on local standards rather than marking up his work. Collaboration over correction. Collaboration. She wanted me to tutor the man who'd just replaced me on my own project. To hold his hand while he dismantled my work and rebuilt it wrong, and to smile while doing it. The next 3 weeks were a masterclass in slow-motion demolition. Toby pushed revised structural drawings to the project server without running them past me. Load paths were wrong. Connection details were copied from a residential template and pasted into a commercial spec. He'd undersized the hold-down bolts on the shear walls by 2 grades. 2 grades. In a seismic zone. In Wellington. Every time something broke, they came to me. Passive-aggressive Teams messages at all hours. "Hey Kira, was this your original detail? Quick question, did you document the reason for the pile depth? Can you just hop on a call and walk Toby through this? Walk him through it. Like I was a GPS for a man driving the wrong way down a motorway. I kept records. Every message, every botched drawing, every email where Vanessa redirected blame. Saved them in a folder on my personal drive labeled insurance. And at night, when the flat was quiet and the only sound was rain on the iron roof, I sat at my kitchen table and read. Not fiction. Not comfort reading. Intellectual property law in New Zealand. The Copyright Act 1994. The difference between work made under a contract of service versus a contract for services. Case law on contractor IP disputes. Engineer Registration Board guidelines on authorship and professional responsibility. I read until my eyes burned and my tea went cold, and I understood, with absolute clarity, that I wasn't just angry. I was right. Under New Zealand law, work created by an independent contractor belongs to the contractor unless there's a written agreement assigning it. My agreement didn't assign it. It explicitly preserved my ownership. Every structural design, every calculation set, every seismic model I'd produced in those first 18 months was mine. And those designs weren't just old projects. The foundation methodology, the bracing philosophy, the connection detail library, they'd been carried forward into every project since. Copied, adapted, reused, but never reassigned. My intellectual property was the skeleton inside their entire portfolio. I called the only person from the old days I still trusted. Gavin Pritchard, the engineer who'd peer-reviewed my early work before he left for a quiet life doing residential consents in Wanaka. We hadn't spoken in 2 years, but he picked up on the second ring. I told him everything. The credit stealing, the handoff to Toby, the contractor agreement. He was quiet for a long time. Kira, he finally said, that connection detail library you built, the one with the moment-resisting frame specs. They're still using that? They're still using everything, Gavin. They never rebuilt any of it. Just kept layering on top like it was bedrock. And the seismic model for the Petwood apartments? My model. My soil interaction parameters. My liquefaction mitigation approach. He exhaled slowly. They never cleaned up the IP chain. Probably didn't even think about it. Marcus was always more worried about cash flow than contracts. He was right. Marcus ran the firm like a Trodai runs a Uda, fast, loaded, and held together with optimism. Legal housekeeping wasn't his style. And Vanessa, for all her polished presentations, couldn't tell a contractor agreement from a catering invoice. After the call, I opened a new browser window and went to the Intellectual Property Office of New Zealand website. Then I opened the Copyright Council resources. Then I opened the Building Act 2004 and cross-referenced the authorship requirements for producer statements. Turns out, if you're the original author of structural designs that are being used in a building consent application, and your IP rights were never formally transferred, you can dispute the use of those designs. You can notify the relevant territorial authority. You can, if you're feeling particularly precise, file a formal IP dispute that flags every consent application relying on your work. They didn't just borrow my calculations. They were about to submit them to Wellington City Council with someone else's name on the producer statement. That wasn't just unethical. Under the Building Act and the Chartered Professional Engineers Regulations, it was a professional conduct issue. I didn't rush. Spent a full week preparing. Pulled every original file from my backup drive. Documented the chain of authorship. Cross-referenced my designs against the current Thorndon project drawings and highlighted every element that traced back to my contractor period work. The connection details. The bracing methodology. The foundation approach. Even the damn spreadsheet macros I'd written to automate the load combination checks, still running in their template 4 years later, my initials in the cell comments. Then I drafted a letter. Formal. Measured. Addressed to the Building Consent Authority, copied to the Engineering New Zealand Complaints Committee, with a separate notification to the NZIA Ethics Panel regarding authorship misrepresentation. The letter stated, in language so dry it could have cured timber, that the structural designs being submitted under the Thorndon Mixed-Use Development Consent Application contained intellectual property authored by me under an independent contractor agreement that explicitly retained my ownership rights. That no written assignment had ever been executed. That the producer statement bearing Toby Fenwick's name on work he didn't author raised questions of professional misrepresentation. I attached the contractor agreement. I attached my original design files with metadata timestamps. I attached the current project drawing showing the copied elements. 47 pages of documentation, organized, indexed, devastating. I printed the letter, signed it, scanned it, and saved it. Then I made a cup of tea, sat on my couch, and stared out the window at the harbor. The silence was extraordinary. No Slack pings. No Teams notifications. No panicked calls from Toby at 11 p.m. asking what a drag start was. Just the sound of the wind coming off the Cook Strait and the distant hum of the cable car. I hit send on a Thursday afternoon at 3:15. The building consent team would receive it before close of business. Engineering New Zealand would have it by Monday. Then I waited. The first sign came 2 days later. A Monday morning. I was at my desk, pretending to work on a retaining wall detail for a separate project, when Vanessa swept into the office looking like she'd swallowed a wasp. She went straight to Marcus's office and closed the door. Through the glass partition, I could see her gesturing. Marcus had his hands on his head. By lunchtime, the Thornton Project Slack channel had gone quiet. Not normal quiet. The kind of quiet that happens when everyone's been told to stop talking. The consent application, which had been scheduled for lodgement that week, was pulled. No explanation to the team. Just a terse message from Marcus, Thornton submission on hold pending administrative review. Administrative review. That's partner speak for something has gone catastrophically wrong and we're trying to figure out who to blame before the clients find out. The clients found out anyway. The developer, a property group out of Auckland who'd already pre-sold 60% of the apartments off the plans, rang Marcus directly. I know because I could hear his side of the conversation through the thin wall of his office. Phrases like "we're working through it" and "minor procedural issue" and absolutely no impact on the timeline, which was a lie so large it needed its own postcode. By Wednesday, the Building Consent Authority had formally requested clarification on the authorship of the structural designs. They wanted to see the IP chain. They wanted confirmation that the engineer whose name was on the producer statement had actually authored the work. They wanted documentation of the assignment of rights. Documentation that didn't exist. Because it had never happened. Vanessa, predictably, went on the offensive. She pulled me into a meeting room, just the two of us, and tried to rewrite history in real time. Kira, when you came on full-time, there was an understanding that all prior work transferred to the firm. That's standard practice. An understanding isn't a written assignment, Vanessa. And standard practice doesn't override a signed agreement. She stared at me. The smile was gone. In its place was something raw, somewhere between fury and fear. What do you want? I don't want anything, I said. I want what's mine to be acknowledged as mine. And I want my name off a project I've been removed from, because right now your consent application has my work with someone else's signature, and that's a professional conduct issue for everyone involved. She left the room without another word. I could hear her heels clicking down the corridor, faster than usual. The next 72 hours were extraordinary. The kind of chaos you can only appreciate when you're standing in the eye of it, perfectly still, while everything around you spins. Engineering New Zealand opened a preliminary inquiry. Not a full investigation yet, but enough to send a formal letter to the firm requesting information about the producer statement authorship. That letter arrived on Thursday morning and detonated like a quiet bomb in Marcus's inbox. The developer's lawyers called. Then their insurance company called. Then their quantity surveyor called, wanting to know if the project timeline was still valid for the bank's drawdown schedule. It wasn't. Not even close. Toby, bless him, tried to fix things by rewriting the structural calculations from scratch. In 3 days. For a $42 million building. In a high seismic zone. He produced a revised set that I later heard described by the peer reviewer as imaginative, which in engineering is not a compliment. Marcus called me on Friday evening. His voice sounded like gravel at the bottom of an empty glass. We need to talk, Kira. Properly. I was on my couch, eating butter chicken from Indian Aroma and watching the lights on the harbor. I let the silence stretch for 5 full seconds before I answered. I'm available Monday. Through my lawyer. I didn't have a lawyer yet, but I called one that night. Fiona Galbraith, a IP specialist in Auckland who'd handled contractor disputes for engineers before. She listened to my story, asked 3 sharp questions, and said, "You've got them. Don't settle cheap." The meeting happened on Tuesday, in a conference room at Fiona's Auckland office. Neutral territory. Marcus came with the firm's lawyer, a sweating man in a too-tight suit who kept clicking his pen. Vanessa wasn't there. I heard later she'd wanted to come, but Marcus told her to stay in Wellington. Smart move. The only smart move he'd made in 4 years. Fiona laid it out. The contractor agreement was clear. The IP had never been assigned. The firm had been using my designs without authorization for 4 years across multiple projects. The current consent application compounded the issue by attributing my work to another engineer. The regulatory bodies were now involved. She paused, let that sink in, then continued. My client isn't interested in destroying the firm. She's interested in being properly recognized and compensated for work that has generated significant revenue and professional recognition for partners who didn't author it. Marcus's lawyer whispered something. Marcus nodded, looking older than I'd ever seen him. What are you proposing? He asked. Fiona slid a document across the table. Retrospective licensing fees for the use of my designs across all projects since inception. A lump sum for the Thorndon project specifically. My name restored to all relevant documentation, producer statements, and NZIA award submissions. A public acknowledgement of my authorship. And a clean exit with a reference that reflected my actual contribution, not the ghost story Vanessa had been telling. The number at the bottom of the page was $650,000. Not a guess. Fiona had calculated it based on standard licensing rates for structural engineering IP, applied across every project that used my work. It was, if anything, conservative. Marcus looked at the number for a long time. Then he looked at me. I built this firm, Kira. No, Marcus, I said, and my voice was steady, almost gentle, because there was no anger left, just clarity. You sold this firm. I built it. They didn't accept immediately. There were 3 more days of back and forth between lawyers, the kind of dense, joyless correspondence that bills by the 6-minute increment. Marcus tried to negotiate. Fiona didn't budge. The Engineering New Zealand inquiry was ticking like a clock in the background, and every day that passed without resolution was another day the Thorndon consent sat frozen and the developers' lawyers sharpened their knives. On Friday afternoon, they signed. $650,000. Retrospective licensing. Full authorship acknowledgement. My name on the NZIA award resubmission. A clean separation agreement. Vanessa was placed on leave the following Monday. Official reason, restructuring. Unofficial reason, the NZIA ethics panel had received my documentation and was asking questions she couldn't answer without incriminating herself. Her LinkedIn went quiet for about 2 weeks, then erupted with a post about embracing new challenges and the courage to pivot. I didn't read past the first line. Marcus stayed on as managing partner but stepped back from the Thorndon project entirely. The developer brought in an independent structural engineer to review the entire design package. Half of Toby's revisions were thrown out. The other half were flagged for further review. Toby himself transferred to the firm's residential division, which was partner speak for go somewhere you can't hurt anyone. I didn't go back. Didn't want to. Instead, I registered my own practice. Ashby Structural, operating out of a small office on Eva Street, just me, my laptop, and a coffee machine that cost more than my first month's rent as a contractor. Within 6 weeks, I'd been approached by 3 developers who'd heard, through the Small World Whisper network of Wellington construction, what had happened. They didn't care about the drama. They cared that my work was mine, that it was good, and that I stood behind it. The first project I took on was a 6-story residential build in Newtown, half a kilometer from the garage where Marcus had started the firm. The developer was straightforward, the brief was clear, the contract was airtight. I wrote every clause myself. The second project was more interesting. A mid-rise commercial development in Petwan, right next to the waterfront apartments I'd originally designed for Langford Fenwick. The new developer had seen my work on that building, tracked down my name through the updated consent records, and called me directly. "Your bracing design on the neighboring building is exactly what we need," she said. "Can you adapt it for our site?" I quoted my rate, which was 3 times what Marcus had paid me as a contractor. She didn't blink. We signed that afternoon. The third project was the one that made me smile. A boutique hotel conversion in Thorndon, 2 blocks from the mixed-use tower that was still sitting in consent limbo. The architect on the project was new, someone I'd never worked with. But the structural brief she handed me was familiar. She wanted a seismic approach based on what she'd read in a published case study, a methodology for mid-rise buildings on marginal soil that had been presented at the New Zealand Society for Earthquake Engineering conference the previous year. I recognized it immediately. It was my methodology. The one I'd developed for the Petwood apartments. The one Vanessa had presented at the conference as the firm's innovation. Except now, thanks to the settlement, the authorship had been corrected. My name was on the paper. My name was in the citation. I took the job. Adapted the methodology for the new site. Delivered the design in 3 weeks. The architect sent me a bottle of Martinborough Pinot Noir and a note that said, "This is the cleanest structural package I've ever received." I put the bottle on the shelf next to my framed copy of Clause 4. 3 months after the settlement, I got a call from an engineering recruitment firm in Auckland. They were headhunting for a senior structural role at a large practice, the kind of firm that does hospitals and airports and university buildings. The salary was north of $180, plus bonuses, plus professional development funding. I thanked them and declined. Not because the money wasn't good. It was. But because I'd spent 4 years being invisible inside someone else's firm, and I'd learned something that no salary could teach. The difference between being employed and being valued isn't a payslip. It's whether your name is on the work. Last month, I was sitting in my office on Eva Street, finishing the detailed design for the Petwan commercial project, when my phone buzzed. A notification from the Engineering New Zealand website. The formal inquiry into the Thorndon producer statement had concluded. The findings were published in the quarterly bulletin, names redacted but facts intact. A firm had submitted structural designs under an engineer's name who was not the author. The original author, an independent contractor, had retained IP rights that were never formally transferred. The matter had been referred to the registration authority for further consideration. I read it twice. Closed the tab. Made a coffee. Looked out the window at the grey Wellington sky, the kind that sits low over the hills like a wool blanket, and felt something I hadn't felt in years. Not satisfaction. Not revenge. Just weightlifting. The quiet unburdening of being seen. That evening, I drove out to the Petwan waterfront. Parked near the apartments I'd designed 4 years ago, back when I was a contractor being paid $55 an hour to do work that would win awards for people who didn't know what a shear wall was. The building looked good. Solid. The kind of structure that would stand through whatever the Hikurangi subduction zone decided to throw at it, because the person who designed it understood that buildings don't just need to be beautiful. They need to be honest. I sat there for a while, engine off, windows down, listening to the sea. Then I drove home, opened my laptop, and started designing the next one. Some people build empires on other people's work. I build structures. Real ones. The kind that carry weight, resist force, and stand on foundations that belong to the person who poured them. If this story resonated with you, here's what I want you to carry away. Know your contracts. Read every clause, especially the ones about intellectual property. If you're a contractor, a freelancer, anyone doing work outside a traditional employment agreement, understand what you own and what you've signed away. Don't assume your employer will do the right thing. Don't assume goodwill replaces good documentation. Keep your files. Keep your emails. Keep your timestamps. Because one day, the work you did quietly in the dark might be the only proof that you were ever in the room. You don't need to shout to be heard. Sometimes the quietest people in the building are the ones holding it up. Thanks for watching. Faded Crown.